Governor Jared Polis recently lost a lawsuit over how he was cooperating with ICE. And now we've learned ICE privately asked the state for help on other occasions, despite Colorado law limiting that cooperation. The state government will not tell our Marshall Zellinger whether it agreed to work with immigration agents in those instances or not.
This is a subpoena that ICE sent to Colorado's Department of Labor and Employment, CDLE. It lists 35 people that ICE wanted employment and contact information about. The 35 people are federally vetted sponsors of unattended immigrant minors. And ICE wrote that they wanted to make sure the kids were not subjected to crimes. Democratic Governor Jared Polis was willing to comply. We know about this subpoena because Scott Moss, a CDLE employee, sued Polis to prevent the state from giving ICE the personal information it was seeking. State law prevents information from being shared with ICE unless there's a court order or it's part of a criminal investigation. Moss won a preliminary injunction in court last month. The judge wrote in his order, the evidence before the court was that no one in CDLE or the governor's office, with the potential exception of the governor himself, interpreted the subpoena to be part of or in furtherance of a criminal investigation.
Let's be very clear. Governor Jared Polis knew about these laws when he directed state workers to share information about undocumented children with ICE.
Denver City Councilwoman Serena Gonzalez Gutierrez was a state lawmaker that sponsored the law preventing the state from sharing information with ICE. It turns out this is not the only time ICE has asked for the state for personal information. We asked and found out CDLE has received 4 requests from ICE this year. CDLE refused to provide us the other 3 subpoenas or the department's responses, citing ongoing investigations. In an email sent to ICE in late May, CDLE even offered to collaborate with ICE. A CDLE employee wrote, "We propose working together to further ensure the safety of the children you are concerned about. These professionals are highly likely to help attain additional information that could be useful in criminal investigations." The next day, that employee wrote, "Please disregard that last email." A spokeswoman for CDLE told me that email to ICE to collaborate was a draft scheduled to be sent ahead of a deadline and was really not meant to be sent. What's troubling, Kyle, is that we now know there are 3 other requests from ICE and likely responses from CDLE, and those are being withheld for a catch-all ongoing investigation, which of course will make me go away.
As soon as they say ongoing investigation, you just say, well, you let me know, you let me know. So sometimes news happens on our schedule, sometimes it doesn't. A couple of minutes ago, you learned of a new development in this.
Right. So the governor has requested through his attorneys to have this case dismissed that allowed for the preliminary injunction. And as I read through the filing, it's because it sounds like he's willing to share publicly available information, which I believe the state law allows, as long as it's not, if it's something that's not publicly available, you're not supposed to share it.
Yeah.
But he's willing to share certain information that they have gathered about some of the people whose names were redacted with the publicly available information about their employers.
We'll see what the judge thinks of that. Marshall Zellinger, thank you.